I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are courtroom hopping into the courtroom of Judge Pauline Freund out of the state of Washington. And this is going to be our first time in her courtroom, or I should say, my first time. Some of you may have been in one of her proceedings before. I have not. So I am interested in seeing how she handles this sovereign citizen case. And with that being said, there's nothing else to be said. Let's jump into this proceeding.
Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and
Yes.
will it be able to be reviewed by federal judges if it gets to that or whatnot? Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoke my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just gonna say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the peace and friendship treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
I assure, if you look at the evidence that I submitted, I assure you I am.
I
Everything I'm
received
saying,
no evidence. I received just your letter. So
right,
I'm not going to,
and
I'm
the
not going to
letter,
grant, I'm not going to grant your motion to dismiss.
okay,
What are we doing?
okay. And I submitted evidence in the letter.
I'm not denying, I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter and I'm not granting your motion to dismiss.
I understand.
Okay, what are we doing?
What about the evidence?
What do you want me to do with the, I don't have any actual evidence. I have your statements.
Right, I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted, you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have
is,
to retrieve it.
I have no way to do that.
You have to
That's your
contact the
job.
courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
You are. You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for me?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The
Okay.
case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter, I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions. So I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give them an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5. Um,
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to
family.
file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like, I don't have any access to the law library.
That's something you'll have to talk to SCORE about. So has any discovery been provided?
I gave him the narratives.
Police reports, that's it.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try if you're not going to agree to try them simultaneously. I can't guarantee you they'll all be tried we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them. Here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term. And then whichever one goes. But we'll have them all set so that it'll depend on who's available and such. Okay. But they are not joined that unless somebody files a motion to actually hear it. But as of now, nothing is joined. Okay.
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Tinwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer of the airport.
It's
Correct.
not an affirmative defense. An affirmative defense would be saying I trespassed, but I had to because I was being chased by someone and I ran into the airport for safety. It was necessity is an affirmative defense.
Okay.
Lawful use of force is a defense.
In that
Just
case,
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
okay, according to your definition, I guess it's not an affirmative defense. But once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. But we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And then also, could I file a motion to appeal that?
You have to actually file it. You can't, you don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal, I'm sorry. So I would get that information from Mr. Ionetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine. We are not courts of record in that sense, like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So there is a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court reporter.
Okay, what's the difference?
I can explain.
I'm ready, Your Honor.
Okay. And it looked to me like what is current speedy in custody, Ms. Chenweller, do you know?
719.
Thank you. All right, Mr. Evans, bail remains $500 each case. We'll see you back here, each count rather. We'll see you back here on June 12th at 11 o'clock in the morning. Stay in touch with Mr. Ionetti. He can help you.
Ms. Judge, Your Honor, my bail was raised. Is there any explanation for my bail being raised? Some of my cases was $250. It went from $250. Yes, ma'am.
Oh, I'm sorry. Did I mean I just said that I changed it right now? I see that.
It was changed by the previous judge. It was raised to $500. She went just off the notion of what the lawyer said, which was inaccurate. And then the inaccuracy was passed on to you as well. And then you were about to redouble down on it.
All right. Thank you for pointing that out, sir. I'm restoring bail to $500 per case.
You mean $250 for some of the cases? And
well, it's $250 per count on cases that have 2 charges.
All right, let me take a look at the paperwork I got and I'll let you know which one said $250 bail.
Yes, Your Honor, I believe that the last hearing that it was pro tem judge and she set it at 500 per charge. And I think she misunderstood that when Ms. Chenweller advised her, it was supposed to be 500 per case.
Correct.
Okay, for a case ending in 2319, that was $250 bail.
No,
Or-
see, there are two counts. Look down below it. There are two counts. There's one count of criminal trespass in the first degree and one count of making a false statement. Both of them are 250. It's one case.
Okay, so you combine the two charges and it comes up to 500. I got you.
Correct. So it's 500 per case, but I'm restoring it to that. I believe there was a Scribner's error in the last order. And I thank you for correcting me, Mr. Evans, or pointing that out. So it is now, so on the case, and similarly, the case ending in 525, that's the last case. There are two charges on that case as well, and it's 250 each charge. Okay, so then
So was I right or wrong?
you were right. I mean, I put it back the way it was, 500 per case.
Okay, and I'll have trial for all 4 cases on the same day, or
We can't possibly do all 4 in one day. We're good, but we're not that good.
gotcha. So,
One second.
and also the letter that I sent you, it's gonna be on file for the public to see all the information I have in there?
Until I receive a motion to seal and we have a hearing on it, yes.
Did you read the backside of it as well, what I
Yes.
said? Okay,
But sir, so this is why I'm encouraging you to look at the Bone Club case, because that sets out the criteria by which a court can seal a document. It's not, I can't just seal it because I feel like it or because you want it sealed. There has to be a
it's
justification.
a matter of national and homeland security.
You can't just say that. You have to show me why it is.
Because it's an investigation.
So again, you can't just say things. You have to, I need the whole story, not just little bits.
You
And
would
just so
have,
you're aware, we are streaming this hearing live on YouTube before you go any further than you want to.
right, so my whole life is in danger at this moment because of this. I clearly wrote in a letter that I'm connected to an investigation that is a matter of national and homeland security.
But you can't just say that. You have to show me the whole thing. I can't just take your word for it that that's an issue. You're muted. You're muted.
I gave you the evidence to prove what I was saying as well.
But you didn't. You just said, I have this thing. You didn't, I don't have the thing. I need the thing.
I gave you the evidence in civil case 24012 out of St. James
Okay,
Parish,
we're
Louisiana.
circling, sir, we're just circling back to things. I do not have that case in front of me. You have to present that case to the court. You can't just say there is a case.
So I have to do it in a motion form, or do I have to, for me to physically get a copy of that, it's impossible for me to do it. My lawyer probably can do it, but it's impossible for me to do it from within inside.
I understand, and we had this discussion at the beginning of the hearing, and you've talked to Mr. Iannotti about that. I can't do any investigation. I am not your attorney. I'm the neutral party. I'm not the city. I'm not you. I will do no investigation. That would be, frankly, I could be sanctioned for doing that. It's up to you to present evidence to the court. It is not the court's job to find evidence.
Okay, in the letter I did present it as evidence.
It's not evidence. It is just claims.
All right, so I actually have to file an actual motion as evidence, and
It's not the motion. You have to file the evidence, the thing itself.
you mean the actual physical copy of the civil case?
Yes, that is exactly what I mean.
I don't have the actual copies of the civil case in front of me due to the fact that I would have to call the courts to get it. And I cannot do that from inside of this jail, and they will not fax that to me from the inside of this jail.
Okay, so we're having the same conversation over again. You can talk to Mr. Iannotti about this. But I can't, there's just a limit to what the court can do. All right, thank you, sir. We'll see you back here on June 12th.
Well, guys, we have come to the end of this proceeding, and man, it was a lot to cover in this proceeding. A lot was said, a lot was done, a lot of questions was asked by Mr. Evans. I felt like the judge handled the situation very well. We see Mr. Evans claim to be a chief of some sovereign tribe somewhere, but wouldn't tell the name of the tribe. He felt like by doing so, it would put the tribe in danger or himself in danger. He also tried the whole, peace treaty thing between the United States and Morocco, but the judge knew about that and pretty much shut that down, saying that, it had nothing to do with the defense or defending of his case. He tried to tie himself to Morocco in a way where he said he was royalty, and so on and so forth. And obviously he meets the criteria of a sovereign citizen. He definitely is in that category, not only by some of the things he was saying, but just the fact of just repeating itself. It just seems like one of the criteria of being a sovereign citizen is you must repeat yourself over and over again, no matter what the judge says. Just keep saying the same thing over and over again. And he definitely did that. And one of the things that I felt like he struggled with, even though he knew some of the lingo that the judge was saying, and he understood some of the proceedings, and that's probably because maybe he's been dealing with the system for a while, but he really struggled with the whole affirmative defense versus general denial. And I think one of the reasons he was struggling so much with that was because in his mind, he felt one was better than the other. Like if he landed on this side, the affirmative defense was better than the general denial. And to the judge explained to him that that wasn't necessarily the case. But anyway, definitely a very interesting dialogue between the two of them. Obviously, some of the things that he was saying definitely sound a little off the wall. Some things I can't confirm or deny, but I wanted to share this case with you. I felt like it was interesting when I first saw it, and I thought it was something that you guys would want to see. And that's what I'm sharing on this channel. Not only the stuff that you guys want to see, but the stuff that's new to me as well that I would like to, touch on and talk about. So thank you once again for joining me. This is Sovereign Citizens Hall of Fame. It is always appreciated. The comments that you guys leave, the subscriptions, the super thanks, everything that you guys do. I just want you to know that I appreciate it. And with that being said, this is Sovereign Citizens Court. And for now, guys, court is adjourned. See you on the next video. God bless.